Welcome, everyone. My name is John Dupre, and I am a principal at Hamilton Brooks Smith Reynolds. I am here this afternoon with Pat Quinlan, an associate in our office. Pat is the real expert in our firm on this topic, as he is also a brewer. What could be better on a Friday afternoon than to talk about beer? The answer is clear. That's to drink beer. And we hope a few of you are having a cold one as you listen to this talk. If you have any questions as you go along, use the question and answer box on your screen. Before proceeding, I thought I'd tell you a little bit about our firm. Our firm is an intellectual property firm. We focus on the protection of patents, trademarks, copyrights, and trade secrets. We have two offices, one in Boston and one in Concord, and we cover a range of technologies. In addition to our two office locations, we have attorneys working remotely from Western Mass, Western New York, and New Jersey. This is a new area of the law for me because it really came about with the growth of craft brewers. But I have been involved in trademark rights and protecting trademark rights, both through registration and through litigation, for over 30 years. And with me today is Pat, and Pat, will you say a little bit about your experience?
Hi, my name is Pat. I've been a patent and trademark attorney for about 12 years and a home brewer for 10 of those years. I started out back, like a lot of people have, back when their wives bought them a home brewing kit for Christmas, and I've gotten to, over the years, build my own system. And so I'm a member of the National Brewers Association, and our firm sponsors a number of other associations, including the Massachusetts, New York, and New Hampshire Brewing Associations. And I work a lot with breweries, and having the brewing experience, I really like working with breweries. I like helping them out protect their trademarks. One client in particular, for example, started out, it was a group of home brewers a long time ago who decided to lease commercial space just for some communal home brewing. They had a system that was about the size of one barrel. Just 5 years later, they've expanded to a huge new headquarters with multiple satellite brew pub locations, and I'd like to say I had a little bit something to do with that, helping them with the trademarks, but honestly, it's really all the hard work that they've put into it.
Thank you. And now you see why I say we have an expert. One of the key things in deciding how to protect your intellectual property rights is which rights are really key for your business. Our firm does a lot of patent work, and in many business lines, patents are important. Not so in this. Really, the key is the brand. And why do you want to brand? What type of rights are you trying to protect? The key is that trademarks establish your market position. The customers, the competitors who see your brand understand they're getting a particular beer at a particular level of quality. You want that market position to be exclusive. You don't want other people to be using very similar marks in the beer industry, such that customers or competitors will be misled and directed to that other product when they're looking for yours. Trademarks are also valued by investors, particularly if you're looking for funding because you want to scale up your business. You want to add more equipment. You want to expand your distribution network. If you go to the funding sources with brand names, particularly if they're registered, you're more likely to get them interested in investing in your product. Over time, what the trademarks do is they represent both the goodwill of your company, all of your products, your brands, as well as the quality level. Everybody believes that their particular beer is at a quality level that they're looking for. The key is when a customer goes and gets a beer with that label, they get the quality level that you expect. And if your brands are not protected and there are other people using them on lesser quality products, it can cause great damage to your company and to your future. Another reason you should be interested in registering your trademarks is because once your mark is registered, it is then on the U.S. Trademark Office's listing of marks. And someone else who tries to come in later and register a mark will be refused because your mark is there taking up that position. So the more of your trademarks that you have registered, the more you're going to be able to prevent other people from seeking to obtain similar marks, and therefore protect yourself basically by taking no further action other than obtaining the registration to begin with. Now, what we hope to cover today here is set forth with these bullet points. First of all, we want to cover what is a trademark. We understand it does have a legal meaning and it does have a legal application. But also, we're going to go through the form options. Trademarks can take many different forms, and we're going to go through some examples of that. Even some things that you won't think are a trademark can actually be a brand identifier for you and your company. Then we're going to talk about how do you select trademarks that are easier to protect and defend, and also easier to register. Certain terms, based on the nature of the term, can be registered on their own without any proof that there is what's known as secondary meaning or consumer association in the marketplace. Those are the best and strongest trademarks, and Pat's going to go through examples of those. But there are other trademarks which tend to be descriptive, which are harder to register, harder to defend, but sometimes they're the brand that you wish to do. And we can advise you and help you to get those, we'll call them more difficult to protect trademarks, to a position where they get the protection. And also there are certain terms that just can't be trademarked, can't be exclusively protected. And for those, we would advise you of how to steer away from them or how to change them in a way that puts you in a position where you can protect the brand. We're going to cover some cost-effective searching strategies. A lot of this depends on the nature of the product. With Pat's experience in this field, he knows where to look to see where the problems may be. We're going to talk about what is use of a trademark. The word use is a well-known English word. When you use in a trademark sense, it means something different. And we're going to talk about what it means to use a trademark, because use is required under U.S. law for registration. We're going to cover how to file for a trademark and some tips on trademarks in this field and how to get both breadth of protection as well as ease of prosecution. The more problems you have during the prosecution of your trademark from the application point to the registration point, the more cost is involved, and also you could be in a position where you're giving up some breadth that you might be able to get. We're going to spend a little bit of time on TM and R-Circle notice, when to use it and what's the value. And then we're going to finish off having a short discussion on what happens when you see an infringer of your mark, when someone is out there starting to take your customers away. What steps should you take to police against them, and what are the options for pursuing them? So we'll begin here with what is a trademark. And when you think about this, you need to think about the two components that are identified here. The trademark has to serve two purposes. It has to be able to identify the product and the service, and then it has to be able to distinguish those products and services from others. There are a number of terms that can identify a product without distinguishing them. And a key example in this field is IPA. It certainly can identify your product, but anybody can use IPA for an IPA beer, and thus it can't serve to distinguish your products. So we're going to emphasize the ones that are able to distinguish your products. In addition, what the mark can do once it's established is to identify the source of the products, where they come from, and also, again, the quality level. So with that, I'm going to turn it over to Pat, and he will take you through some trademark examples.
Thanks, John. So I believe John alluded to the fact that trademarks can take many forms. So what are some example forms that they can take? Well, shown on the slide here, we have words, slogans, letters, numbers, logos, and colors, shapes, and sounds even. So let's go through some examples. Words. These are one of the most common forms of trademarks. It gives protection just for the word and confusingly similar words. It's broad protection. There's no limitation to any specific logo or design. Some examples that I have personal experience with are the terms resurgence and singularity. Let's show an example trademark registration for a singularity. So I don't know if any of you have ever seen a trademark registration before, but this is one of the more modern types. We've got the nice United States of America Patent and Trademark Office seal at the top. We have the mark, singularity. We have the registration number over on the side, the date that it was registered. We have the owner to the right of that, Community Beer Works. I may have referred to them earlier. We have what the trademark covers. Below that, it says for beer in class 32. And it also shows when it was first used. Now, one of the important parts of a word mark is that right below that it says the mark consists of standard characters without claim to any particular font, style, size, or color. And this is important because if someone else has decided they wanted to use the term singularity for beer and they think, well, I'll just make the use a really crazy font or add a really distinctive logo, it doesn't matter. This still covers that. So a word mark is actually it provides very broad protection. So you might think, what are the things that you want to trademark? What sort of word marks? Well, number one, your brewery's name. Maybe your flagship beer or beers that you have available year-round, or maybe a certain series that you have. For example, the singularity example that I showed earlier, that's for a series of beers throughout the year. Next up is slogans. One example is experience great beer. A slogan is much like a word mark, maybe a bit longer, more like a sentence. Again, it's not limited to any specific design. Let's show an example of one that I've had some experience with. This is for Resurgence Brewing Company, and a slogan they use very often, experience great beer. One difference that you might notice with this is that for the goods that it covers, it doesn't just say beer, but there's a whole litany of subcategories of beer underneath that. I personally prefer just to have beer. Not that this is inaccurate, though. This company does actually make all of these subcategories of beer. But as I'll refer to later, it's usually best just to specify beer as the goods that you cover. Next up, we have letters. So a set of letters can be a trademark. These are often abbreviations. Some common abbreviations are BBC, ZBC that I've seen. I know there's probably a lot of different breweries that use BBC, but a lot of these abbreviations end with BC for brewing company. CBC, for example. You can use an abbreviation as a registered trademark for your company if you commonly use that abbreviation, let's say on your bottles. So it actually has to be used with the bottle. So if you have a logo that's prominently displayed and it says BBC on it, you could probably register for that mark. Of course, it's already been registered, as I'll show you on the next slide. I'm sorry, this is ZBC. This is for Zephyr Hills Brewing Company, a brewery in Florida. The BBC example I used before actually is a registered mark, and that is for Bluegrass Brewing Company in Louisville, Kentucky. Numbers can also be trademarks, and you can register them as trademark registrations. A common number that's used with in the brewing industry is Magic Hat's number 9 for their pale ale. I'm sure a lot of people are familiar with that. Another form of numbers that are used in beer names is an area code. I know around where I live in Buffalo, New York, there's a beer called Buffalo Kolsch 716. 716 refers to the area code of Western New York, where this beer is made. And there's a lot of breweries around the country that have been starting to incorporate area codes into their beer names. Another interesting one is 668, also called Neighbor of the Beast by New England Brewing Company. I find this to be interesting because I once made a beer a long time ago that actually won a Best of Show in a competition. It was a robust porter, and I called it Mark of the Beast. The reason I call it that is because it came out to be 6.66%. So I find this to be a little interesting, the 668 Neighbor of the Beast mark. Let's look at a registration for a number. This is owned by Magic Hat, and it's for the number 9. You can see that the hash mark, the number sign, and the number 9 are part of this mark. And this is a little interesting too because not only can you have numbers or letters, but you can have special characters. More common special characters, exclamation points, question marks, hash symbols, maybe an @ sign, things like that. Those can be part of your trademark registration as well. So far, we've only been looking at trademarks that include numbers, letters, those kinds of characters. But another very important aspect of trademarks is a design component. You can register a trademark for your logo, your company's main logo, or a design that you have on a label on a can of beer or a bottle. Many companies, such as Magic Hat, file for both the standard character marks, with just letters and numbers, and the logo separately. And that's actually a common strategy. This, by Resurgence Brewing Company in Buffalo, is a registration for a buffalo hat logo. So they have a registration for the term Resurgence, a broad word mark registration, and they also have this registration for their logo. This gives them the broadest coverage that they can because they have a separate word mark and a design alone. About these logo marks, it might be worth mentioning that you can include color as a part of this mark, or you can just leave it as black and white. I prefer to leave it without color and black and white. I think that's a bit broader. So what designs might you want to trademark? Your basic logo that you put on everything, anything that you put on some glassware, maybe some t-shirts, a sign in front of your establishment, on your cans, on your bottles. These are all things that you should consider possibly registering as a trademark. Another one is tap handles. All right, moving on. Now, speaking of colors, apart from a design, an actual color can be registered as a trademark. This is not very common in the brewing industry, and it's not very common in a lot of industries, but some examples are pink for insulation, owned by Owens Corning, or UPS's brown that they use on their trucks and their boxes. There is actually a use of color for a local brewery near me. It's a bright green distinctive color that they use on their logo and the tap handles. When you walk into a place, let's say, that has their beer on tap, you can instantly tell if they have the beer on tap because of the bright green logo.
Yep, and Pat, it may be that it's not just a singular color, but it could be a color combination. There's a recent lawsuit down in the Midwest involving green and yellow by John Deere. So it's the green and yellow color combination. So you could, in your brewing industry or in your particular branding, come up with a color combination, not just a singular color as well.
Yeah, thanks, John. That is true. And that's a lot of places that tend to register colors or a combination of colors as trademarks are a lot of universities too. And if you're thinking that you might want to have a logo that represents a university that's close to you and you want to use those same colors, you might want to think twice about that. So here's an example of a registration for pink for insulation by Owens Corning. You can see that the drawing has lines in it. It doesn't actually show the colors. This is an older registration. It does say in the registration that the drawing is lined to indicate the color pink. But the trademark office since then, and very recently, has gone through a bunch of updates, and all for the better, I think. And newer registrations actually do show the color. Next up is shapes. A shape can be a trademark, just the shape of something. An example of that is Michelob's old bottles that look like a drop of water. They used to have a registration for that. I don't know if a lot of you remember those old bottles, but they're no longer in existence. Well, some may exist, but they're no longer being sold. So that registration has since expired for non-use. But a current example is Jack Daniel's bottle. I'll show you a registration of that along with a picture of Jack Daniel's bottle and a similar bottle. Jack Daniel's registers actually a number of various aspects of this bottle. This example registration shows the overall bottle design. This is interesting because in recent years, Jack Daniel's has been pursuing lookalikes, like alleged lookalikes, like the picture on the right by showing Lone Hand whiskey. And there's actually a pending case in a federal court in California against this alleged infringer. We don't know how it's going to turn out yet. This is very recent. But this is something that you could consider protecting as well. You might think, what kinds of shapes could you trademark yourself? Well, your product is generally put out in normal shaped cans or bottles, but you might be one of those breweries that puts out a special customized bottle, like Michelob did. But maybe if you have a custom-made growler that you distribute your beer with, or even your tap handle, a point-of-sale display like a tap handle, if you have a really interesting design that you use across all your brands, that could be something you can think about registering the shape. So last on the list here we have sounds. Also not a very common trademark type, especially in the beer industry. Outside the brewing industry, there are things like the NBC chime that goes ding, 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 or the Intel tones. There is one example that I can think of in the brewing industry, and that's the recent marketing campaign by Bush that combines the word Bush with a fizzing sound that sounds like Bush. And so you've probably seen some commercials on TV or seen a billboard for that. Anheuser-Busch actually filed a trademark application for this sound, and it has been approved. It could register soon, but there's a little bit of wrinkle with that. I'll touch on that a little bit later. Here is an example trademark registration for a sound. This is for the NBC chimes, and you can see that the description, as best as they can, describe what the sound is. All right, so far we've gone through some example trademark forms, but it's also important to note that there are different levels of trademark distinctiveness, and John touched on this a little bit, mentioning generic and descriptive terms. So not all trademarks are equal. Some are stronger than others and provide more protection. Going from weak to strong here on this slide are generic terms, descriptive terms, suggestive terms, and distinctive terms. Taking generic terms first, like John mentioned before, IPA is an example of a generic term. It generically refers to what the product is in India Pale Ale. It's not protectable. Possibly you might see some people that have an IPA trademark registration, but it invariably includes some sort of design element. So really they're trademarking the design, not the words IPA. Descriptive terms. Descriptive terms are not typically strong trademarks, but they are protectable if they have a secondary meaning. So if they've acquired some distinctiveness beyond their descriptiveness that they include. Sierra Nevada, I think, is a good example of this. Sierra Nevada is a geographic region where the beer is made. Now, yes, I know they've since opened up an area in North Carolina in the past few years, but originally Sierra Nevada is where the beer was made. So it's a bit descriptive of the beer, where it was made. But since they've been used for so long and so widespread, they can actually file for federal registration because their trademark has acquired a secondary meaning among the consuming public. If you do not have that secondary meaning, there is a possibility of registering what's called on the supplemental register. There's two different registers, a principal register and a supplemental register. Principal register is preferred. Supplemental register can be used for descriptive marks. Right. Next up, suggestive terms. Now, many beer names are what are referred to as suggestive terms. Parts may be descriptive, but the name overall suggests something more. One example is Nugget Nectar, made by Troegs in Pennsylvania. Part of it's descriptive, the nugget part, nugget being a hop varietal, and that's used very much in that beer. So the beer actually includes something that has the name Nugget. But the nectar addition to it adds something more. Hops don't really have nectar. You can think of it as maybe being nectar. It's really lupulin, not a nectar. So adding nectar to nugget adds something more. It's really more of a suggestive term than descriptive. So that would be registrable on the principal register without having to acquire any secondary meaning. Another example is the alchemist. The alchemist, the normal meaning of alchemy, transforming metal into gold. When I first heard of the name alchemist, that's what I thought of. And I thought it was a cool name because when you think of brewing, you think of transforming ingredients into something better, sort of like transforming metal into gold. But when it comes down to it, brewing's not alchemy, alchemy's not brewing. So the term alchemist is more suggestive, not descriptive. They could file for trademark registration without any acquired distinctiveness. Distinctive terms. These are the best trademarks because they are the most distinctive. They are not related to beer at all. They are arbitrary words, for example, used in a new context. Two examples I have here are Moose Drool by Big Sky. I love Moose Drool. But it has nothing to do with beer. It's a comical name, and many of these arbitrary words applied to the beer context happen to be comical. And maybe that's how your customers remember those names or choose to buy them in the first place. Another example, Purple Monkey Dishwasher by Evil Genius. At first, it sounds like a random grouping of words, but I think it has been used before. I think there was an episode of The Simpsons where they played a game of telephone, and at the end, someone said Purple Monkey Dishwasher. I think it's used to refer to a random mishmash of words. But regardless, it is distinctive for beer because it's never been used in this context before. So these distinctive terms, these terms used in a new context, this is an example outside the brewing industry is Apple. So Apple for computers and cell phones. The term Apple has nothing to do with computers, so it is distinctive. Likewise, Moose Drool and Purple Monkey Dishwasher and those similar names are also distinctive when used with beer. Now, the most distinctive are coined terms. These are terms that have never existed before. One example is Michelob. Now that's existed for a long time, but apparently that is a name that Anheuser-Busch coined a long time ago for a premium line of beer at the time. Pinglehead is an example of one that's maybe lesser known, maybe more known down in Florida. It's the name of a brewery in Florida. Doing my research, I've never found that Pinglehead has ever been used before or anything like it. So it's a pretty distinctive coined term. Outside the brewing industry, examples of coined terms are Exxon and Kodak. These words didn't exist before, making them extremely distinct. So now that you've come up with your name, a good distinctive name, what should you do with your trademark? Well, you should make sure that the mark is available for use. One way to do that is to check the industry resources like Beer Advocate and Rate Beer. I personally like those because those two sites tend to be a collection of almost every beer name that has existed, at least in modern times. And what's also nice is that sometimes you can tell if a beer or if a name has been abandoned. So it hasn't been used in 3 years. Let's say they started using it 6 years ago, hasn't been used since 3 years ago. Maybe you could adopt that mark for yourself. I have to warn you that Beer Advocate and Rate Beer are not definitive on that matter, but it can give you a starting point. Another thing you should do are some basic internet searches. It's actually surprising how some people will pick a name for their company without doing just a basic internet search to see if something out there exists. Now, a little further than that, you could do a trademark screening search through the trademark office. That's something that we have a lot of experience doing, and that's one of the first steps that we always do. And what that does is it looks for currently registered marks, marks that used to be registered and are now abandoned. It looks for pending applications. It looks for applications that were once pending or are now abandoned. These are all important things to know. A further step that you can take is to have a full search performed. And now typically it's cost effective to have an outside searching service do this. And they have a number of different resources that they look through. And what they do is they provide you a very detailed report of any uses of your proposed mark that are out there. Plus they're very good at providing any uses of phonetically similar terms or terms that include similar letters. It's a very thorough search, and that's something that if you want to be more sure that your mark is clear, that's something that you'd want to do. And you can review that detailed result, or you can give them to your attorney and have your attorney's thoughts on that. Now, if it's a very important term, like your brewery name before you open, you may want to consider getting a clearance opinion, a written opinion from your attorney that your mark is okay to use. And that can be useful in the future if anyone does approach you for a potential infringement of their mark. So after you go through all that, you've chosen a mark, you've determined that it's cleared. What do you do then? Well, you can begin using the mark. As I mentioned before, you could use it before you clear it, but there's always a risk of infringing someone else's trademark. You hate to go through all the cost of starting a business just to change your website, change business cards, change signage, change everything that goes along with, with your logo and all the wasted marketing efforts that have gone into the old name. So it's very important to clear it first. You can also file an application for registration, of course. Now, it's important to note that there are two variations of applications that you can file at the Trademark Office. There are applications based on your current actual use, so after you've started using it with your product, but also very, very, very important, and a lot of people might not know this, you can file an application based on your intent to use the mark. This means you can get your foot in the door at the Trademark Office before you start actually using the mark, which is important in the brewing industry because it can take years from the first inception of your concept for your brewery and your brewery's name until you can actually start selling under that product, do all the licensing processes that you have to go with. So what you can do is at the very beginning when you settle on your name, file an intent to use application, assuming that is allowed by the Trademark Office. You will have up to 3 years to then use your mark later. And a lot of times during that 3 years, you can complete the licensing process, the brewery build-out process. So it's very important to know that you can get your foot in the door early. Along those lines, I like to stress that it's very important to file applications as early as you can to avoid other people from filing before you. I have seen personally a situation where a brewery decided that they were going to put off trademark filing because when you're first starting a brewery, I know you're pinching pennies. Every dollar, every cent counts. So they put off the cost of filing trademarks for a later time. And they also thought, well, maybe the process would be a little too difficult too. In this particular situation, another brewery in another part of the country filed for a very similar name before they ever filed for one. And so it's a bit unfortunate of a situation, but that's why you address these things as early as you can. So if you decided to file an application, what do you need to do to file for your mark? Well, one, you need to, at the Trademark Office, you need to specify what your mark is. What words does it consist of? Do you have any designs, etc.? You also need to specify the goods and services. Now, I always say, if you're going to be producing beer, just specify that your goods are beer. That is probably the broadest descriptor that you can use for your industry. Nothing more is required. Some applications include more, which is fine, like beer, ale, and porter. It's a bit redundant, I think, but if, let's say, you say that you declare at the Trademark Office that you are using your mark for beer, ale, and porter, and you don't make a porter, that's technically a false declaration. So it's a problem, and an example of something that comes up a lot is people put down non-alcoholic beer. Well, how many breweries are going to be making non-alcoholic beer, really? So just put down beer. Another thing you have to do is pay a filing fee. And you have to pay that filing fee for every class of goods or services that you want your trademark registration to cover. There are 45 classes of goods and services that you can choose from. Beer falls under class 32. So usually for the basic trademark application for a brewery, it's going to be for one class. Maybe 2 classes if you're a brew pub and you want to cover some restaurant services too. You could also cover additional goods, some ancillary goods like t-shirts, glassware. Those are all going to be in different classes, by the way. And you have to pay a filing fee for every single one of those classes. So it increases the cost of the trademark application plus costs of renewals down the road. And now, if you want to be really, really, really thorough, you can include all of these ancillary goods. But I suggest basically the 1 class for beer, maybe 2 if you want to cover restaurant services. It's also very, very important to note that you have to file in the name of the brewery. I've also seen this before too, people filing in the name of the founder or the owner or the president of the brewery. You can't do that. It will invalidate the application or the registration. You have to file the name in the name of the brewery. There's one time when you can file in the name of someone else other than the brewery, and that is if the corporate entity, the corporation or the LLC, has not yet been formed. It's okay to file in the founder's name, say at that point, but after you do form your brewery's corporate entity or LLC, you have to assign the trademark application to the brewery. So you might look at this and you might think, well, okay, there's an interface on the USPTO's website for filing an application. I'll just save some money and do it myself. But I can't tell you how many times I've seen simple little mistakes that end up either invalidating an application or registration or reducing the coverage that you can possibly have. And I'll say our clients do think, and they have found it very efficient, just to send me an email and say, we want to file a trademark for this, and the next day we'll have one ready. And it's very simple and easy for them, and they find it to be very cost effective. So on the subject of examining your application, once you file an application, it goes through an examination process. It will be pending for about 3 to 4 months before it's examined, before an examiner even picks up and looks at the application. At that point, he may approve it to move on to the next step, or he may issue a rejection at some point.
On the point of rejection, we did get a question about what if we identified beer and related merchandise? If you did do that in an application, what you would end up is one of the rejections that Pat mentioned here, because the examiner would require you to clarify the nature of the related merchandise. You would then get back to identifying glassware and T-shirts and suddenly be in the 3 classes that you had talked about previously. So yeah. You can't avoid the multi-class requirement by putting a term like related merchandise in.
Right. And what happens is if you initially describe beer and related merchandise and you decide, well, I don't want to add all those other classes, because you can add some classes later possibly, T-shirts and glassware, and then pay more money for that. But let's say you don't want to do that. You're going to have to cross out related merchandise and get rid of that. And that puts a little question on your application. Do you really cover that anymore? So it's better maybe from the beginning just to have beer and not have to delete anything from your application. All right. Anyway, there are a number of grounds that you could be rejected on. Perhaps that your mark is too descriptive, in which case, or a part of it's descriptive, and an examiner may require that you disclaim part of it, and that's fine. Like the terms brewing company, it's common, to be required to disclaim that part. Another rejection, and the one that you kind of maybe fear, is the likelihood of confusion with another existing mark. And we have to be worried not only about other beer names for this type of confusion, but also wine names or names for spirits that are made by distilleries like Jack Daniel's or various wineries. This does happen. The state of the current law is that beer, wine, and spirits are related for the purposes of likelihood of confusion. So sometimes you get that, and I've seen that in the past too. There are some things that you can do, maybe in agreement with the other winery, because you're not necessarily in competition with each other. But this is something that you probably want an attorney to handle and guide you through that process of entering into an agreement with another company. So let's say your application is approved, whether from the outset or after you responded to a rejection. It'll be published for a 30-day opposition period. During that time, anyone else can oppose your mark if they want to. Now, opposing a mark is not easy. It's like filing a civil action in federal court. And so if you do happen to get someone who opposes your mark, it is a serious process that you need to go through. Sometimes it could be ended quickly. Sometimes it goes on for a while. That's something you probably want the attorney's help with. Or if you want to oppose someone else's mark, if you notice that someone else is trying to register something that's very close to your mark, and it's gone through the application process somehow and gotten approved, you can start an opposition period or an opposition proceeding. Ideally, the examiner won't raise any issues in the ideal situation. And if that happens and there's no rejections you need to respond to, the total time from filing to registration is about 8 to 10 months. A lot of that is just waiting time. It's that 3 to 4 months of waiting for the examiner to pick it up. It's then waiting for the opposition, waiting for the application to be published, waiting 30 days through for the opposition period, and then after, if there's no opposition filed, there's just some processing time where it takes the trademark office to actually issue a registration. So ideal time for your planning is 8 to 10 months. So I mentioned before that you can file intent to use applications or based on actual use. If you do file an intent to use application, you're going to actually need to show that the mark is being used. Or when you file initial use-based application, you have to show that your mark is being used. What does trademark use mean? Well, for other industries, typically you have to sell products over state lines to fall under federal jurisdiction. But breweries are different. So all of that federal licensing and also state licensing. But the federal licensing that you need to go through to make and sell beer puts you under federal jurisdiction already. So I know it's a pain from the beginning, but it actually gives you a little bit of a bonus when you file trademark applications. So because you're regulated by the federal government, you don't need to worry about selling across state lines. If you just sell out of your local establishment, you still qualify for federal registration. Now, to use your relationship, or to use your trademark with beer on the products, you need to use it in a close relationship with the goods. So it has to be on packaging or labels. Some good examples for you to think about when you're using it with beer is on a bottle label, but a lot of places might not have bottle labels or can labels, let's say, but a keg collar. You send out a keg of beer to one of your distributors or to a local restaurant, and you have a keg collar on there with your beer's name, that's use of your beer with the product. Also on tap handles. Tap handles are examples of use. And also draft boards. I know a draft board is kind of like a sign in the background, and it's not very closely related with the beer, but it is a point of sale display. So a draft board is also acceptable use to show that you're using the beer. It's important to note that there is no use if it's only on advertisements. So if you're lucky to have a billboard out there advertising your beer, that's not an actual use with the product. Or if you have some flyers, let's say we're having a tap release party, that flyer is not going to be a good enough use with the product to show that you're using it for federal registration. I want to go back to my Bush example, the marketing campaign that goes Bush, and they've had their trademark application allowed, and their trademark application covered beer, a product. Now, so it's been allowed, and what Anheuser-Busch has done, I've noticed, is they've filed an extension of use, because you have up to 3 years to show that you're using your mark before it either becomes abandoned or registered. And every 6 months, you can file an extension of use to show, to keep your registration pending. Now, so Anheuser-Busch hasn't shown their use yet, and you think, well, it's been used, it's on commercials, it's on billboards, I see it. But as we've just discussed, that's not an acceptable use with a product. So I'm not sure what Anheuser-Busch is going to do. I think it's interesting. They might develop, let's say, maybe a point-of-sale display at a grocery store or something that makes the Bush sound. I guess that would be acceptable then. But it'll be interesting to see what they actually do. So if you ever see that in a grocery store, that's why. Along these lines about use, if your trademark application covers services, like a restaurant component, use for services is different than products. Use for services can be on advertisements. So on your website, let's say, for your brew pub, just using your mark on your website, advertising your brew pub, that's good enough for the class covering services for your trademark application. All right, I'm going to hand it back to John here to discuss some trademark application costs and other considerations.
Thank you, Pat. We did get a question about shapes, and I just want to cover that before we move on. And I'm going to go back to slide 21, which was the shape of the Jack Daniel's bottle. And when you're considering shape marks, there are actually two different kinds. One can be the shape of the product itself, and the other can be the shape of the packaging. And really, in this industry, you're really talking about the shape of the packaging. The shape of the product itself doesn't really apply for a drinkable beverage. And that's what Jack Daniel's registered here, was the shape of the packaging. And they were able to register it as a distinctive mark because the packaging itself was distinctive. If you're trying to register the shape of a product, which again wouldn't apply in this area, you have to show secondary meaning. So the shape of the product is viewed as a weaker trademark than the shape of the packaging, which is this Jack Daniel's example. So I'm going to move on to some of the costs to consider when you're going to proceed with the trademark application. Generally, as Pat recommended, we file in just one class for beer. That should always be your starting point. If you're short on money, make sure you get your beer application in. The cost for preparing and filing the application is in that range, and there's a trademark office fee of $225. There actually are multiple fees depending on how you file. There are certain approved descriptions of goods, which if you use one of those in your application, you can get a reduced filing fee. If you file electronically as opposed on paper, you get a reduced filing fee. We do our filings in the most cost-effective way, and that's the filing fee that you're going to get. If the application is filed based on intent to use, which is something you're going to do when you're trying to reserve your right to the trademark before your use occurs, you must make the use before the registration issues, and when you file that statement of use, there's an additional fee of $100 that's paid, again, on a per-class basis. All of these fees are on a per-class basis. An application for beer, glassware, T-shirts, and brew pubs is a 4-class application. So all of these prices are quadrupled. Once the registration issues, it actually can remain in force forever. However, between the 5th and 6th year after registration, you must show it's still in use. The Trademark Office adopted this to try to clear the dead wood. All of the applications that have registered but have subsequently been abandoned, they get removed by cancellation if the statement of use is not filed between the 5th and 6th year. And the filing fee for that to the Trademark Office is $325, again on a per-class basis. And then every 10 years from the registration date, the registration must be renewed, and you must prove use with each renewal. You can continue with your registration forever as long as you prove use every 10 years. And then we do get questioned frequently about which trademark notice to use and when to use it. The two options are TM and sometimes SM, but usually TM or R with a circle. You can use your TM once you've adopted a mark. You can use it for common law marks before an application is filed and while the application is pending. The R circle mark has more restricted ability to be used and should only be used once the trademark has been registered and only used for the goods covered by the registration. For example, if you have a registration for beer and you want to produce glassware and use the brand on glassware, you wouldn't be able to use the R circle on the glassware. One way you might be able to argue that you could use it is if I won't call it related merchandise, but the promotional materials you produce in connection with the beer may be able to use the R circle. But in general, you should only use the R circle on goods covered by the registration. And why would you do it? You want to make others aware of your claim of trademark rights. Someone who sees a brand and adopts something similar can't argue that they weren't aware you were claiming trademark rights if you have a TM or an R circle in connection with it. And if you actually get into a battle with somebody in court, which is something we generally try to advise clients to avoid, if you have used the R circle notice appropriately on the involved goods, you might be able to increase the level of damages and the damage period in which you can recover your rights. If you have appropriate use of the R circle, the damage period may start from the time the infringer started using the infringing trademark. If you didn't use the R circle, the damage period may start when they had knowledge or notice of your trademark rights. So that could substantially reduce the amount of time in which they'd be liable for damages. And that's really important when you're trying to get an infringer to settle and how much of a sword you can hold over their head. Okay, and when should the notice be used? It should be used on the goods. All of the places that Pat described where you would use the trademark, that's where you would use the trademark notice. And then what happens and what steps should you take to police your marks effectively? Now, one of my partners, when I was talking to them about this, has said, when trouble is brewing, hop to it. That's what this slide relates to. First of all, register your trademarks. If you see somebody out there that's close to yours, hopefully you've registered your trademarks early. If you haven't, register them now, because you could send a letter to somebody who you view as an infringer, and they could beat you to the trademark office. You would want to register your trademarks as soon as you could. Even if your rights in use are earlier, you have earlier priority common law rights. If you have your application on file earlier, the trademark office generally deems the party with the earliest trademark filing date to be the one with superior rights. So if you see somebody out there infringing your trademark and they haven't filed, you had better file. And then that gets to the question of, make sure you're first. I have had situations where one of my clients has received a cease and desist letter from an owner of trademark. And it turned out that my client was using the brand for years before the owner of the registration. It was an interesting response when we took the cease and desist letter from the other party and turned it into a cease and desist letter to them. So make sure before you respond and before you send out that first letter that you're first. And how can you be first? Just as Pat said, by use or by filing an early intent to use application. Both of those identify your dates where your priority of rights arise. And one thing to keep in mind, if you think you're safe and you're about to send out a cease and desist letter, you're a brewer in Massachusetts, there's an infringer in California, and you say, I'm going to get them, I'm going to send them a nasty letter, referred to every now and then as a nasty gram. The recipient of that letter in California can decide to file a declaratory judgment action in California and pull you into California for that lawsuit. So you need to assess who the recipient is, whether they're the type of person that might start an action against you. Look at their history. Have they been involved in litigation before you send that company a cease and desist letter? If you're in the situation where you're a brewer in Massachusetts and the recipient of the letter is a brewer in Massachusetts, you don't have to worry about that, because the action for infringement would take place in the federal court in Massachusetts. In addition to pursuing an infringer that you see in the marketplace, you may see either a pending trademark application or an issued trademark registration for a mark that's similar to yours. Again, you want to make sure you have priority. You can file an opposition to prevent a pending application from issuing as a registration. And after the registration is issued, you can file a cancellation action in the trademark office. Again, as Pat mentioned, it's sort of like a mini litigation, but it's within the trademark office with rules that are set forth by the board. Finally, and usually the last action, is to pursue federal court infringement action. When would you do this? Most likely when you're about to face imminent danger, or you're going to lose your trademark rights, or you're going to lose value in your trademark rights in the minds of consumers, competitors, others in the marketplace. Federal court infringement litigation is expensive, but sometimes it's necessary and very effective. So now we have a few questions, and we hope that you have joined us in a cold one. We do have a question here about foreign trademark rights, and I'm not sure it was very clear, but trademark rights are on a national basis. We've been talking about registering trademarks in the United States, in the United States Trademark Office. If, for instance, you're importing or exporting your beer to Canada, and that's a big market for you, you should consider registering in Canada. And for most foreign registrations, it's country by country. There is an opportunity if Europe is a big market for you to register in Europe in the European Union. It is a little complicated in coming years because the UK is leaving the EU, so you may have to do 2 applications there. But that is an option for you. So if you're going to be go from a small craft brewer to an international multi-nation brewer, you may need to consider the other country protection. And Pat, I think there's a question here for you. You had talked about, I think, the opportunity when somebody was using a trademark that was not exactly on your goods, but in goods that were somewhat related. There were opportunities of being able to resolve that situation.
Right. I think you might be referring to when I was talking about a rejection that comes up to your application. Yours is for beer, and something's brought up for a similar trademark that's used for wine. And I've had that experience where I've had such a rejection. And now the winery and our client, the brewery, we're not in competition. They're in different parts of the country too. And so what we did is we contacted that winery and we negotiated a coexistence agreement between the two, saying that they would prevent confusion between their marks, and they don't think there was any confusion at all. And we filed that with the trademark office, which was able to overcome that rejection. And so those are the kinds of agreements that, if you work with your attorney, you can possibly obviate a rejection at the trademark office. Now, I have a question, and it says, is protection for local-only breweries that are not going to engage in interstate commerce? And I believe we did talk about that a little bit. The requirement for trademarks under federal jurisdiction is that you have to use the trademark in commerce that is regulated by Congress. For a lot of industries, that qualification is normally met by providing your goods in interstate commerce, because then the federal government regulates interstate commerce. But as I mentioned before, for a brewery, you have to go through a federal licensing process. They force you to do that. So you are regulated by Congress. And so you automatically qualify for federal protection whether you sell across state lines or not. Okay.
Pat, just a further point on that. One of the things to keep in mind is you can use your mark locally and get a range of common law rights. Supposing you're only in Massachusetts and that's the only place you brew and you distribute your product locally. If you run into a situation where somebody else comes up with a beer in Texas and California and they federally register the trademark, your rights as the first common law user are limited to where you've established those common law rights. And the second user, who's the registrant, gets the rest of the country. New York, Connecticut, may be a problem for you. So even if you are a local business, you should take those key brands. And because you do have the federal aspect that Pat talked about, you should still register those brands to secure your position in the marketplace. And again, it's relatively inexpensive compared to the cost it would be to get into a battle with those companies on even if it was an easy resolution like a coexistence agreement.
All right. I have another question. Is the filing date affected by any rejections in the process? So this is about the filing date of an application, trademark application. No, the filing date, you have your filing date. So let's say it's for an intent to use application and you want your earliest priority. You file in the early stages of your planning. And let's say you face rejections that increase the process by, let's say, up to a year. That's okay. You still have your foot in the door. You have your filing date, your priority date, back to that original filing date. It may affect the registration date, but that's really not as important for what you're concerned about.
Yeah, there's one very unusual circumstance in which it's somewhat relevant, but it's unusual. If you file originally an application for registration on the principal register, which you would do for the stronger of the marks, and during the prosecution amend back to the supplemental register, the trademark office will change your filing date. It's a real unique, unusual situation, but Pat is right. Once you get your application on file, that gives you your data protection from there. I have been asked to advise you that everyone who's registered here will receive an email with us. We will share the slides and the recording of this webcast with everybody there. Thank you. We do appreciate the questions. Pat, did we cover all the ones we got?
There's one last one asking about, is there a trademark for color, such as Bud Light Blue? And yes, we did touch on that earlier. You can trademark colors if it's a distinctive color or a color combination. That is possible, yes.
Yeah, but for colors, it's very difficult, requires a lot of time. Look in the slides when you get them at the registration for pink by Owen Corning. It was first used in 1956, the year I was born. It was used for over 30 years with Pink Panther emphasized commercials before it was even registered. So if you have those types of colors, it requires a lot of secondary meaning, a lot of sales, a lot of emphasis on the colors in the promotional materials. So it's very, very difficult, but we covered it just because it is an option. So with that, we thank everybody and look forward to having you all at our next webcast. Thank you.